Hello, everyone. Welcome to the Critical Legal Talk series. I'm Alexis Álvarez Nakagawa, lecturer at Queen Mary and the host of the series, which are co-organized by the Law Department at Queen Mary, University of London, and the Group of Critical Studies in Politics, Law, and Society at the University of Buenos Aires. Hannah Fransky, today's chair, had a last-minute personal emergency and won't be able to join us. Hannah coordinated and organized this session with Professor Menke, so we are very grateful to her and regret she cannot join us today. We have the enormous pleasure of having Professor Christoph Menke with us. Professor Menke is widely acknowledged as one of Germany's most important and interesting philosophers today. He is a professor of practical philosophy at Goethe University, Frankfurt in 2009. His work has focused on political and legal philosophy, theories of subjectivity, ethics, and aesthetics. He is regarded as one of the last representatives and part of the so-called third generation of the Frankfurt School. His studies on law and violence, or his book titled Law and Violence, published by Manchester University Press in 2018. His critique of rights, published by Polity Press in 2020, and more recently, his Theory of Liberation, published in 2022, which is, if I'm not wrong, not yet published into English, translated into English, have made an important contribution to political theory and in particular to legal scholarship. Professor Menke will present a paper titled Democracy and Rights, where he discusses the tense relationship between these two elements in our political arrangements, in our political systems. After that, we'll open the floor for questions. Let me say that this seminar will be recorded and will be posted online at Queen Mary's webpage and at PODE's webpage after the event, respectively. Professor Menke, thank you so much for being here today. It's really a pleasure to have you here to discuss your paper, and it will be great to listen to your presentation. And so the floor is yours.
Yeah, thank you very much. So can you hear me? Yeah, yes. I guess. Okay, thank you. Thank you, Alexis Alvarez, and thank you, Marcelo Raffin, for having me, for inviting me to be here. I'm very pleased and honored to be part of that series. If I could utter a wish, that would be that to put on, most of you put on the cameras. It's really strange to look into this black, I don't know, we say tiles. So and now I see myself, horror. Oh, okay, in big. Can I change this? Maybe not. Okay. Yeah. So
can we change the view?
I would like to change the view, but I don't know exactly how to do this.
If you go to gallery view, you'd be able to do it on the top right-hand corner of the videos, if you see.
I see. Yeah, thank you. Thank you. Gallery, I can go, yeah, but much better. So it's really odd to look at oneself on the screen. Okay, thank you for turning on the cameras. As Alexis said, I want to address the question of the form of rights in the modern, specifically modern understanding that we refer to in German by talking of subjective rights. I think in the Anglophone context, one would rather talk about individual rights from the perspective of politics. And I do this because I think the strongest, and most convincing way of a critical engagement with rights is from the political perspective. So starting from, not only starting, but one of the first prominent articulation of that political critique of rights was of course Marx's on the Jewish question. So in that line of thought, there's a persistent and very, I think, convincing critique of the form of rights from the perspective of political community, of the political decision making, of political democracy. And so I want to take up the question of rights from that perspective and ask the question or ask the question whether there is a good political reason, a reason that is specifically political for the implementation of the form of rights in the construction, in the constitution of a political community. So you will see this in a moment. So that is my question. So the perspective of my engagement with the form of rights, and we can maybe in the discussion come to the relation of that perspective on rights and the relation of that perspective on rights to other perspectives. Okay, so my question is, why subjective rights? Why did the modern bourgeois revolution since the end of the 18th century declare the rights of citizens as, they say, human beings? Why did and do these revolutions declare the right to have rights, to be addressed and treated as a subject of rights, a holder of subjective rights? One need only look at the proceedings of the French National Assembly to see that this decision was by no means self-evident. Even a revolutionary as resolute as the Comte de Mirabeau, who was of course familiar with the modern idea of natural rights and was eventually to head the committee that drafted the Declaration of the Rights of Man and Citizen, went along with it only with great hesitation and little enthusiasm. He didn't find such a declaration urgent or important for the revolution that he had started, by rejecting the king's order to the Assembly of the Third Estate to disperse. To Mirabeau, to declare rights did not seem to follow at all from the revolution's decisive basic concern. So it's very interesting to look at the notes of these debates, and you see how hesitant Mirabeau was even to take up that task to think about the Declaration of Rights. For this basic concern that Mirabeau was interested, the basic concern of revolution was political equality. The old regime, so to start with a very simplifying opposition here, the old regime which was overthrown by the revolution had been an order of domination or of inequality. This inequality concerns most of all power, and power means here the power to govern. The ancien regime is defined by a radically unequal distribution of governmental power. This political inequality is claimed to be grounded in a natural inequality, as you know. The unequal distribution of the power to govern is justified by the unequal distribution of the capacity to judge. Accordingly, only some are capable of judging what is good and bad, just and unjust for all, and hence capable of governing. Domination is thus that relation in which someone who is capable and hence entitled or even obliged to do so judges for someone else about his or her life. The lord, the ruler, represents, he or she establishes and safeguards the good and just order for his or her subjects. This is, to continue with this simplistic understanding, this is where the first blow of the revolution is directed. In beheading the king, it affirms the equality of judgment, the equal capacity to judge. The revolution declares that all are equally able to judge and consequently to govern. It confirms the claim that, as Descartes had put it right at the beginning of his Discours de la Méthode, the bon sens, the power of judgment, that the bon sens, the power of judgment, is the most fairly distributed thing in the world. With this claim of equality, which I think is obviously not empirical, or if we take it empirically, would be obviously wrong. Not everybody is empirically equally able to judge. With this claim to equality, the traditional justification for domination breaks down. It gives way to the modern revolutionary idea of equality. Equality in this revolutionary sense is political equality. It means that everybody has an equal part in the collective process of judging, or in the collective process of self-government of a community. Revolutionary equality means, in that sense, egalitarian democracy. Now, if this is right, if this is a correct understanding of what the revolution is in its initial impulse about, we understand why Mirabeau was so hesitant and unenthusiastic when the proposal was made to draft a Declaration of Rights. His hesitation follows from the insight that it is a huge step from the revolutionary idea of equality, politically understood, to the declaration of civil rights as human rights, a step which is quite unclear in its logic and justification. For the idea of rights does not follow somehow by itself logically from that of political equality. Political democratic equality does not mean, by definition, one could say, equal subjective rights. Furthermore, Mirabeau's lack of enthusiasm in declaring rights, i.e., as he says, in articulating the fundamental principles, that is the category that Mirabeau is interested in, not rights, principles of justice in that specific form. So this lack of enthusiasm is the expression of a premonition that became a fact for Marx 50 years later. In his reading of the non-political part of the Declaration of Rights in the second section on the Jewish question. Namely, that the Declaration of Rights does not merely not follow from the democratic idea of political equality, but that that declaration would rather bring about consequences that jeopardize the realization of that idea. The name of these consequences is, of course, bürgerliche Gesellschaft, bourgeois society. For the order of subjective rights that the revolution declares is the legal infrastructure of the emerging bourgeois society. And the bourgeois society is, in Hegel's term, the dissolution of ethical life, and hence that social form which blocks the fulfillment of man's political destiny, as Hegel said, to lead a universal life. So to participate in the self-government of the community. As Mirabeau already sensed right at the beginning, revolutionary democracy's idea of political equality and the form of subjective rights stand in relation of conceptual and normative tension, which Marx then would develop further into the claim that they even stand in relation of contradiction. Now, on the Jewish question, Marx has called this relation a puzzle, a Rätsel, he says, that cannot be easily solved. It cannot be solved internally. For Marx, there is no positive connection between democratic equality and the form of subjective rights. Their relation is, as I said, a contradiction to Marx, and the form of subjective rights thus needs an explanation, according to Marx, by an external causal source, which for Marx is the very reality of bourgeois society that the form of subjective rights bring about. Marx's explanation of the form of subjective rights. So why was that form implemented by the revolution? That explanation, that answer follows in Marx's functionalistic logic. It explains the Declaration of Rights by its socioeconomic effect. So the cause is the effect, is the logic of a functional or functionalist explanation. Now, although I agree with Marx's claim that subjective rights constitute the normative infrastructure of bourgeois society, that they in fact indeed go hand in hand, I disagree with his separation of subjective rights from democratic equality. Marx, I think, misses in their text the dialectical logic of their contradictory relation. So they do not only stand in a relation of contradiction, but there's an intimate connection also between subjective rights and democratic equality, which we have to understand, and that makes it a dialectical relation, as we could say. Marx, I think, fails to see in that text how political equality and rights are connected precisely by their contradiction. Another way of putting this objection against Marx's explanation of subjective rights in terms of their necessity for capitalism would be a methodological argument. I think in a certain sense, there's a certain problem, which is obvious maybe, of reductionism here. Because Marx, as I said here, developed something like a functionalistic account or explanation of the Declaration of Rights. I mean, explaining the declaration by its social effects. It fails to grasp the true ground or reason of this new modern form of normativity. It is therefore this functionalist explanation also a bad or limited form of critique, and it is so according to Marx's own definition of critique. For it misses what Marx in his critique of Hegel's philosophy of the state had proclaimed more or less at the same time as he wrote on the Jewish question, the task of true philosophical criticism. Such criticism, Marx says, neither judges the falsity of some institution, nor does it explain it from outside. Yeah, so critique is neither judging, saying yes or no to something that we do all the time anyway, nor explaining it functionalistically or causally from outside. True criticism, he says, I quote, by contrast, shows the inner genesis of the thing it criticizes. It, again, Marx describes the act of its birth. It explains them, it comprehends their genesis, their necessity. So true criticism then would be neither normative judgment nor functionalist reduction, but rather, one could say, a genealogical reading of the question at hand, of the form at hand. The attempt of the following is to sketch the outline of such a critique of rights that is true to this methodological idea. So to try to understand the inner genesis of that form, what is the inner logic that constitutes it, brings that form about. So that is the program for the following. I want to try to answer the question, why subjective rights, as I said, in a genuinely political sense. I thus understand the question as asking, why use the form of subjective rights to articulate, shape, and regulate the political process of an egalitarian democratic self-government? Why to use that specific form to say everybody has the equal right as a subjective right to participate? Why would you do that in that form? And to answer that question, I will proceed in two steps. In the first step, I will identify the problem that modern revolutionary democracies try to solve by introducing the mechanism or form of subjective rights. This question in the first step concerns the question why, that means in response to which problem democracy, we could say, have become liberal. So why did, and I understand a liberal democracy as a democracy that organizes itself in the form of subjective rights to participation. This is meant to, this turn to the underlying problem. So the genuine political problem that drives one to that solution. This is intended to bring to light what Marx calls the inner or internal genesis of the form of rights. That is the first step. So what is the problem at the root, in a certain sense, of that move to declare political rights in order to organize something like an egalitarian democracy? In the second step, I want to discuss whether subjective rights are a suitable instrument for solving this problem. So what is the problem is the first question. Is the solution by the form of rights a good solution, a good answer to the problem? So yeah, can they solve the problem, or on the contrary, do they open up a new problem that this kind of liberal constitution cannot solve? I will try to show how and why the liberal establishment of subjective rights is a political strategy, a strategy we could say of politicization, which indeed undermines itself. And then we end with a certain kind of paradox of rights, one could say, and the question will be, but I will not have an answer, what can we do with that paradox? What is the practice that would, the political practice that would be able to do justice to this paradox? Okay, so these are the two steps. What's the problem? The second step is are the form of rights a good solution to the problem? So politically understood, to say this again, the question why subjective rights asks why political constitutions should use the instrument of rights to accomplish their task to organize and thereby constitute political freedom or political power. So that is how I understand the question. Why do we do this in that form? For the sake of brevity, I will call such a constitution that makes use of that form liberal. I thus use the term liberal in a narrow and very specific sense. In the specific sense, one could say of liberal democratic, or even more specifically in the sense of liberal because democratic. Most liberals, of course, would not have used the term in this way. Yeah, this is clear. Yeah, because most liberals were not Democrats. So that this conjunction of liberal democracy, it's of course a post-war, post-Second World War invention. But and I, in sense, project it back and want to say that the moment you make the decision to organize the democratic or the political community in the form of rights, you, in a certain sense, define that constitution as a liberal one. The question thus is, why do liberal constitutions declare subjective rights in order to organize the self-government of the polity? Before we try to answer this question, because I think there is a very good reason for doing this, it might be useful to distance myself from two extreme positions that do not or cannot even pose the problem. These two positions are both extremes because they relate the two sides of this relationship, the political constitution and the form of subjective rights, only externally. And I think we need an internal connection. The first position sees the political constitution and the declaration of subjective rights as completely independent from each other, indeed opposed to each other. This is an example for this is the position of Carl Schmitt in his constitutional theory, Verfassungslehre. According to Schmitt, as you remember, modern constitutions have two components. He calls the first one the rule of law component, and the second one the political or democratic one. The rule of law part of the constitution is understood by Schmitt as spelling out the consequences that result from a substantive preliminary decision. This is the decision by liberal constitutions in favor, as he says, of bürgerlich, bourgeois freedom, personal freedom, private property, freedom of contract, freedom of trade and commerce, and so on, unquote. More precisely, following Schmitt, the liberal constitution's basic decision to value bourgeois freedom implies, as he says, and I will be brief because I assume you are familiar with this, a principle of distribution according to which the individual sphere of freedom is in principle unlimited, while the authority of the state to intervene in that sphere is in principle limited. Yeah? So any political state intervention in the sphere of personal freedom therefore needs a specific extra justification, yeah? Because the sphere of personal freedom is taken as the starting point, as pre-given, one could say. The liberal decision thus grants individual freedom principle priority. It establishes that the state treat the freedom of the individuals as pre-given, as its precondition or presupposition. The task of the constitutional declaration of the form of subjective rights then is to secure this bourgeois liberal distribution between the individual and the state. That is, for Schmitt, the only task of the form of rights, to secure that distribution in which the personal freedom is taken as pre-given. This is why, according to Schmitt, the liberal declaration of rights remains alien to the state's internal, genuinely political constitution. It is anti-political in nature. Since subjective rights are about securing the priority of individual freedom, there are no rights in the other political component of the constitution. Yeah, there would be just a contradiction in terms to even think so. This part of the constitution is concerned with a problem in which individual freedom, according to Schmitt, has no say. It is about the organization of the political process so that an instant of power is constituted whose decisions can be considered the expression of the identity of a specific people. Now, that is the definition of politics here. Okay, so that is the first position in which the two elements are simply externally related or even seen as having nothing to do with each other, to say this simply. The second position, which is also not able to ask the question, not able or not willing to ask the question of the political reason for subjective rights, indeed tries to exclude it from the outset, is the standard liberal one. It is the counterposition to the first, to Schmidt's position. According to this second position, individual participation in the political process has to be organized and secured by a special subtype of subjective rights, besides and in addition to the rights of bourgeois personal freedom that Schmidt considers. Here, in that standard liberal account, political participation is therefore seen as just a further content of subjective rights. Yeah, so we have all kinds of subject rights, property, contract, and so on. And in addition, we have the right to participate in the political process. It is treated, as Alexei puts it, as one of the competences individuals have that go along with holding rights. Competences in this view that Alexei takes over from Hofeld's private law definition of rights are, roughly speaking, legal rights to change one's legal position, i.e. one's rights and obligations or duties. The liberal position understands political rights in the same way as rights to change legal positions. It defines the liberal position that it never gives a reason for its identification of political empowerment as a subjective right. For the liberal position operates on the, I think, false assumption that to grant someone an equal normative status at all means, by definition, and cannot mean anything other than that he or she has a right. Yeah? To have an equal normative status is, in that view, standard liberal view, the same as to say he or she has rights. Thus, for instance, Ronald Dworkin, but this is just one example about many, opens his investigation into the logic and content of rights by declaring, quote, "The debate does not include the issue of whether citizens have some moral rights against their government. It seems accepted on all sides that they do," unquote. Yeah, so I know many sides that would not accept that, but here this is taken as the self-evident starting point. In its naive version, liberalism naturalizes the form of subjective rights and thus also applies it without asking why to the political process. The basic concept of private law, most prominently contract and rights, define here also the field of public law. So they're just exported from the one field to the other. You see this with the use of competences in Alexei, which is a private law category, which is then used as a category to define the public law. In public law, the claim, the entitlement to political participation. Conceptually or logically, liberalism is the privatization, in that sense, of politics. In a conceptual sense. So it uses private law categories for analyzing political processes. Now, neither of the two ways, I want to say, of avoiding the question is convincing. The form of subjective rights is neither external to the political process, as Schmidt thinks, nor is it its self-evident form for which there is no alternative, as Dworkin thinks. Rather, it must be understood as being grounded in an internal problem of the political process, in a problem of political normativity itself, or a problem in political normativity itself. So this is now what I want to show in the next few minutes. To see what this problem is, I want to recall first and briefly the normative point of the political constitution. As I said before, the Constitution constitutes. It does not regulate the political process according to some pre-given moral ideals or norms. Rather, the Constitution brings the political process about in the first place. Its rules are constitutive because the Constitution institutes a polity, as Rousseau said. To institute a polity means to transform, this is again Rousseau, the people from a multitude into a unity, which then can be called a state, or in Rousseau, the general will. It is a misunderstanding to think that this political formation or transformation is solely about creating an instance of supreme political power with the attribute of sovereignty. Rather, its point, I think, the point of this idea that we need to form a political unity in that sense that Rousseau is here describing, and that also already Hobbes had in mind. This point is normative. It is about self-government or political freedom in the sense of autonomy. The normative claim of the modern constitution is that the people can only become self-governing, autonomous subjects if they form a unity. And the argument for this claim is that without the unity of the people, so the unity of self-governing subjects, all government is merely the rule of some over others, of one part of the community over other parts. So you have to overcome the partition of the community in political terms to form a unity in order to say there is a self-governing unity that has overcome relations of political domination. This more or less Skinner's argument in, if you remember, in that text, The Genealogy of the Modern State, where he tries to remind us of the normative point of the category state in the modern sense. The normative point of the formation of the people into a political unity, a state, is nothing other than the attempt, I want to say, to overcome domination. Political unity is the condition of political freedom. Now, while political unity is thus normatively necessary, I want to say for normative reasons, it is structurally unrealizable. And that is the problem where rights come in. It cannot be realized because of the very structure of the political unity. There cannot be it has to be a political unity, but there can't. As the advocates of political freedoms through unity since Hobbes themselves have registered, the formation of the people into the unity of the state always produces on its reverse side a remainder that cannot be integrated, that cannot be recognized into the political process. The formation of the political unity produces something unformable, over against, or even hostile to the political form. This formless remainder has been described under different names: the crowd, the rebel, the masses, but also in Tocqueville, the idiocy of merely private passions and interests, or in Hegel, the nullity of bourgeois life. So it's in all of these, you can trace, you can find in a certain set of symptomatic reading, which does not need much sensitivity. You can find in all these conceptualizations of political unity the acknowledgement that there will always be something that cannot be integrated in political unity, that stays outside. The polity can try to deal with this unassimilable remainder in different ways: oppression by the police, regulation and control, education and activation, for instance, by the welfare state. So this is how the welfare state deals with the masses, the rebel. Instrumentalization by charismatic readers, Schmidt's idea, and so on. But in all of these strategies, the unformed and unformable remainder that is produced by political unity formation as its own other is recognized merely in its facticity, but not in its right. The remainder has no right. It cannot have a right, for right is defined here in that initial move of political unity formation politically as being grounded in the contribution to or participation in the political process of forming a unity. And the remainder is precisely that which, or he or she who, does not contribute or participate. Like the bourgeois does not politically participate because he's a nullity, as Hegel says, politically seen. This is the problem, I want to say, or I want to claim, that lies at the bottom and defines the starting point of a liberalism that can be truly called political. It starts with the acknowledgement of the unformable remainder, the acknowledgement of that which cannot and will never be integrated into the political process of unity formation. Or put differently, it starts with the acknowledgement of that which is not and cannot be represented by the decisions of the political unity, because being stubbornly particularistic, it does not contribute to the formation of the general will. Liberalism, in its truly political sense, thus proposes a counter model of political representation. Political representation not as the formation of the unity, but rather as a mimesis, the mapping or replication of the people in its difference. Not its difference in political matters, but its difference from and over against the political unity as such. By such a representation, so I want to say rights are a mechanism in order to secure the representation of that which is not and will not take the form of political participation in the political unity, the non-political, the representation of the non-political in the political. And that means the political process becomes self-reflective, as we say in Germany, Luhmann or Hegel, or take whoever you want. It is political in a self-reflective sense or mode, precisely by representing the non-political, which is different from any political unity, in the political. Okay, now my time is already up, so I have just made the first step. So I will try to summarize very briefly the second step, so that we have some time for discussion. So the second step is about the question. I mean, I think I hope that became clear. I think this self-reflective transformation of political community, of the political unity, is a decisive and important step which we have to preserve. Yeah, so that means the task that we have is from the beginning a double task. Yeah? And I think in a certain sense you will have seen, I mean, that in a certain sense it's about the tension, one could say, between the primary move of liberalism and the primary move of a democratic order. So the one move is to say, we need, in order to overcome social relations of domination and their representation in the political order, we have to constitute a political unity. The counter move, or the other move, is to say the political unity will always rely on a mechanism of exclusion. Yeah, of producing something. Exclusion is not really the right term, but producing something which cannot become a part. Yeah, which will forever be no part. Yeah, and the attempt then is to say, okay, to think these two sides together, we need a radical transformation of how the political community, political unity works. It needs to take a self-reflective form. Yeah, so that is the problem. And if I had time, I now would discuss the question, or start to discuss the question, whether the form of rights actually is a good way to institutionalize this double structure, this self-reflective structure. Yeah? And I mean, in a book, I mean, The Critique of Rights, which I've published some years ago, I tried to show why I think it's not. Yeah, and maybe to just sum this up, my main concern about the question when it comes to the question whether the form of rights is actually able to implement that task of self-reflection in an adequate form is that the form of rights has an implicit, or relies on an implicit logic of naturalization, I want to say, in a certain sense, taking up a claim, the critical claim of Marx. Yeah, so it always deals that, or analyzes that, or presupposes that which cannot become a part of the political process as something that is as if it were given by nature. Yeah, so in the German tradition of speaking of subjective rights, that is the natural freedom of arbitrariness, of willkür. Yeah, so that freedom we have by nature, and therefore it because it's a natural property of human beings, it has to be recognized as something that the political process is not able to touch, or is not legitimate to touch in the form of rights. Let's say, in the British tradition of the theory of rights, one would rather speak of interests. Yeah, so that is the category that is so important in a certain kind of utilitarian strand of thinking about rights, coming from Hume in a certain sense. But that is a different question. So they speak of interest, but interests have a similar status. Yes, the interest we have, and the primary interest is, of course, this is in Hobbes, the interest in self-preservation, is seen as something that defines me by nature, and not me, but everybody by nature. So therefore, because it's a definition of man by nature, of his or her nature, this is the reason then why it should be protected by rights. So that is, let's say, the most general argument or line of critical argument I want to develop, that rights fulfill that task, which I have tried to define as, I think, the task that modern political communities have set for themselves, namely operation of self-reflection, in such a way that they, as I said, naturalizes that which is the other of the political process. And then, of course, the further question would be, is there an alternative? And I stop with that.
Thank you so much, Professor. I have so many questions. I can imagine that people in the audience will have many questions as well. So let's open the floor. Please write your questions in the chat, or just raise your hand. In any case, please try to be brief to give time to other people to ask questions. So the floor is now open.
You can also ask any kind of question to the second part, which I didn't present. I'm really sorry. I mean, I'm doing this for so many years, but I'm still not able to stick to the time. So the text is always too long. So, but I think it was also distributed. So if you want to read it, you can do. But feel free to ask also about that part, which I didn't present.
I can try to break the ice with a question which is related to this second part in a way. So by the end of your paper, by the end of the paper in which you based today's presentation, so you ask whether it is possible to avoid the paradox of rights, that is, whether it is possible to decouple, right, to separate, on the one hand, the good intentions behind the subjective rights, that is, I'm following your description. According to your description, this will be the protection of the individual from state domination. Let's put it in those terms to say it simply.
Right.
So if it is possible to decouple these good intentions behind the subjective right from the bad consequences that usually rights have, that is social domination in the private sphere, let's say in capitalism, that will be the market, the relations of production, and so on. So you contend that the critique, is not enough to answer this question, about the possibility of the decoupling these two instances, and that we have to turn to speculation and experimentalism to answer this. So I totally agree with this. I think it's totally accurate. But could you, develop a little bit further? What do you have in mind? You mentioned at the end, you make a brief reference at the end and also at the beginning of the article to Bernstein's idea of radicalizing liberalism. But I'm not sure that you wanna really, follow that path. So I was wondering, what do you have in mind? I know that you said at the beginning of the presentation that you don't have a clear answer to this, but I was wondering if you have any thoughts. And then my second question, which is related to the previous one in a way, in a very loose way, and relates to, to our discussion before about the extension of rights to non-human beings. So my second question would be, we have this paradox of rights, right? But nowadays we can see that rights are extended to many different kinds of subjects, which are beyond the human being. So we have seen over the last years a proliferation of rights and the extension of rights and legal subjectivity to non-humans, that is to animals, nature, rivers, rainforests, but also AI, robots, and so on and so forth. So how does the paradox of rights play in these cases?
Very good. Yeah, thank you. Those are very important and difficult questions. I start with the first one. So first of all, briefly just to recapitulate a move I make in the second part for those who haven't read it. So the talk of a paradox of rights, is very common. Wendy Brown, for instance, uses this quite often and in a prominent way. And I want to give that formula a specific reading, and therefore I don't like that terminologies so much, but in a certain sense it has the structure of a tragic irony of rights. Yeah, so that paradox is not simply a contradiction between two sides. Yeah, but rather I want to say it's the reversal of a good idea at the beginning into a bad outcome. Yeah, so think of Oedipus. Yeah, so he wants to do everything right, and then by the way in which he proceeds, he produces its own fate. Yeah. So in a sense that I want to say that is more the fate of rights. So because that teaches us, I think something about the structure. It's not that there's a good side and a bad side, but there is I think a basic important insight in at the beginning, at the bottom of the idea of rights. And then the question is that insight realized in the right way? And I ask this question in such a way because with a contradiction you cannot do much. Yeah, so a contradiction is a contradiction, that is the end of practice. Yeah, while with a tragedy you can do something. What can you do? You can go back to the beginning. Yeah, so you can remember the beginning and maybe think about taking another course. Yeah, so to go back to the beginning of rights, not to dismiss the form of rights, but to remember what was their good idea at the beginning, and then to think about alternative routes that might open up. Yeah, so it's rather already the talk, although it sounds different, but when I talk here of a tragedy at the end, or I use the metaphor of a tragedy or tragic reversal, I mean it in the sense of opening the question of an alternative way of operation. Yeah, so in that sense, it's exactly goes in that direction you mentioned. I think the problem is the following. And I think, so in a sense, I'm maybe only reiterating the problem, but maybe also shifting it a little bit. And then we can see where, yeah, okay. So, if I'm right that the mistake, so to speak, yeah, that is made, the tragic mistake, the tragic failure, on the route that the rights declaration take is to get from that beginning self-reflective delimitation of the political unity to a certain kind of naturalization of that which is on the other side. So then if that's the mistake, the solution would be denaturalize the other. Yeah? Think of the other of the political community in a non-naturalistic way, yeah, without naturalizing it. Yeah, that would be the first step one could do. Yeah, the second step would then mean, okay, what does denaturalization means? Yeah, so you would say that which is the other of the political has, in a certain sense, to become a subject, a topic for the political deliberation itself. Yeah, so we would need a political deliberation about the other of the political deliberation. Yeah, so denaturalization can only mean we together have to decide, yeah, whether this is something that should, for a moment, to a certain respect, not be forced into political participation, not be forced into be transformed into a political argument, but left alone. Yeah, so left for itself and as a free space, right, for maybe idiocy, as Tocqueville would have said, yeah, for doing things that do not contribute politically and socially, yeah, which maybe are what the matter of that which the Greeks called idiots, yeah, so unintelligible, not meaningful, not productive, yeah, so but rather maybe creative, maybe a little bit mad, and so on and so on. But this limit, yeah, I mean, so the decision about what can make claim to that status can only be a political deliberation itself, right? So we would then, so the paradox would shift, right? It would rather mean it's not the paradox. I mean, the paradox would shift, and maybe it's not so paradoxical then anymore, that we have to open the political process into a deliberation on that which should be kept outside the political deliberation. Yeah. So, and maybe that is not really a contradiction anymore. It's a difficult task, yeah, but then we can try to spell out how that could function. Yeah. Okay, so this is not an answer, but this is the direction in which I would like to develop the first question. The other one is very complicated, and because especially on the background of what I just tried to say, because I mean, the question is, of course, the question of representation, I think, here. Yeah. So how can, yeah, because if we extend the form of rights, the talk of rights to non-human beings, then we give up something which was constitutive, at least for the modern understanding of rights. I think Waldron says this somewhere, namely that we treat the rights bearer also as somebody who is an articulator of rights and a claimant of rights. Yeah? And therefore, in a certain sense, modern rights always already had a certain kind of political moment in it. Yeah, so subjective right is never passively given to me. Yeah, and I'm just taking it, yeah, or I'm receiving it passively. But the understanding of a modern right is something I claim for myself. I want it, I articulate it, I legitimate it, and so on and so on. Yeah. So to be a subject of rights means, in that elementary sense, to be a political subject. That was the modern understanding, I think. Yeah. So therefore, the revolutionary beginning of the Declaration of Rights is so important. Yeah. So the rights are not handed over to me, I have to take them. Yeah. So, and I have to claim, then I defend them, and so on and so on. And that cannot be the case here. Yeah. So the river will not go to court. The river will not be able to articulate itself, and so on. So in some sense, that is, I think, the danger of that move I see here. So do we really want to give up that unity? Yeah. So of having a right and claiming a right, having a right and interpreting the right, and so on, and developing the right, and being able to say what I mean by it, and so on and so on. So that is the danger I see here, you see. And I see that it can be very efficient to do this at certain points. Yeah? So I mean, maybe the only efficient way to make important progress in the field of ecological politics. So I see the strategic advantage of that talk, but I see that danger, right? So that we maybe become accustomed then also to an unpolitical understanding of rights in general, and also our rights. Yeah. So as if I were like a river, so that somebody has to speak for me, somebody has to grant me the right, somebody has to defend it for me, while I should be myself the one who does it. Yeah. So, and then, of course, the alternative question would be, what are the alternatives here? So, and what would be the compared to that strategy would be, let's say, a talk about what is good, yeah, what is a good, instead of, that is the alternative, right? Instead of rights, to talk about goodness, and I rather would go that way, but for the reason I just tried to indicate.
So just to be sure, it would be like to go back to the previous ethical notion of law, a law, based on the idea of justice, a law which would be closer to the Roman idea of law that we can think about. Is that what you are suggesting?
Yeah, in a sense, I fear that's all I have to say about it. I mean, I'm not really happy with that idea, but in a certain sense, I think we need at least a strong element of that idea, right? That by the legal order and by legal mechanisms, we implement a certain idea, substantive idea of justice or goodness, right? Which, of course, different from the Romans, we would not derive by looking at nature or contemplate the objective order of the world, but that is the outcome of what we agree on. Yeah. So, and I think that in the end, we cannot avoid this, I mean, especially with the ecological crisis, we cannot avoid that very complicated and hard transformation of our self-understanding, which would lead then to agreeing that it is good. Yeah? So to treat us and nature in a certain kind of relation, and it's bad the way in which we do this in what they call the Anthropocene, or others call the Capitolicene, the capital time of nature relations. So I think that transformation is not something we can skip. Yeah. So skip the transformation in our understanding of how we should do this. Yeah. So how it is right or it's good to relate to ourselves and to nature at the same time. And if that were necessary and possible, is it not all we need, right, to deal with natural phenomena, with nature differently? Of course, I think the question, the strategic question that is asked at the moment, I think by many activists, and I think I take that very seriously. Therefore I come back to this, is, and what do we do meanwhile? Yeah, because we're very far away from that shared understanding of what a good relation to nature would be. I think, I mean, it's a lot of talking about this, but if I look at the political reality, I mean, it's not really visible. It's not, it does not have power. Yeah, maybe it has intellectual. I mean, it's something we share in an intellectual debate, but I don't see this as really changing practices yet. Yeah, in a deep way. And what do we do in that intermediary phase? Yeah, do we not need to use the form of rights, the strategy of rights, the tool of rights, right, in order to make important steps in that direction? And I don't want to deny that, not at all. I mean, that would, yeah. If it does the job, it's good, yeah, if it works.
Thank you, Professor. So we do have now some questions in the chat and also a hand raise. So let me start with the question in the chat. I have a question from Professor Rafin. Marcelo, would you like to ask your question or should I read it? Okay, I read it then.
I can read it also then, okay.
So it says...
Sorry, yeah. No, you can do it, yeah.
Okay, so it says, Professor Menke, thank you for your lecture and for sharing with us your thoughts. Could you please go back to the idea of the mechanism of exclusion, which concerns the problem you identified in subjective rights in relation to democracy? Could you please develop it a little bit more?
Yeah, I think that I noticed this when I came to that point that, I mean, I didn't really offer, I think, conceptual argument at that place. I was just referring to, I think I spoke of a symptomatic reading, right, of the texts that are, I mean, that articulate that idea of political unity. So, for instance, in Rousseau or in already starting with Hobbes, so that we can see there in a symptomatic reading that the way in which they think of the constitutional, as Rousseau says, the institution of that unity, there's always left a moment outside. Yeah, so this was my claim. In a certain sense, one could say it's a weak and soft version of what something Agamben would say. Yeah, so I mean, so not with all maybe the ontological and background of that claim. Yeah, but I noticed that. And I accept, I mean, acknowledge that this is not an argument still why this has to be the case, right? And I think the argument can only be made. No, I mean, that's maybe too strong that I think that I know how it only can be made, but it would require in a sense, let me be brief. So require something that Adorno, I mean, this is what I have in mind. So therefore, let me say this. Yeah. So the negative dialectics between the universal and the particular. Yeah. So that there is no neutral or all-inclusive, all-inclusive universal language that can do justice to the particular in all of its respect at the same time. Yeah. So any universal concept, any universal language and discourse will only be one-sided, will only do justice to the particular to a certain extent, right? And that the dream of a neutral form of universality, of an integrative and encompassing, comprehensive, I mean, idea of universality is false. Yeah, that is the assumption in the background. Yeah, so that there will always be a remainder, something in the particular perspective, something in that cannot be fully acknowledged in a given universality, and therefore the dialectic between the universal and the particular has to be left open. Yeah, so it has to be an interminable, infinite process of negotiation. And this is, in a certain sense, something I have in mind, right? So that the opening up of the political unity to that infinite negotiation with that which cannot become a part in it. But I acknowledge, I mean, that the argument, I think, would for that claim, even in the political field, would have to be a more general and a more grundlegend, more foundational argument, right? Something like in the discourse of negative dialectics. So something about the logic of our concepts, the logic of our discourse, the logic of our language, and so on, right? So I didn't give any argument of this type here, but that is the direction in which I would go if I could in order to answer your question. You see that, I mean, that is just hinting at the argument, not really presenting it yet, but it would be of that kind.
We have another question in the chat from Sergio Fasan. So the question is, in the book, I assume that he's referring to your critique of rights. In the book, you speak of counter rights. Could you explain further? Could you explain them further?
Yeah, counter rights, it's the name I give to that other understanding of the claim. So counter rights means a claim of, using the language I just tried to use in answering Professor Raffin's question. So the entitlement or the claim of the particular over against the universal, that entitlement, yeah, that is the rights moment here, which is not grounded in what I call a naturalizing or positivistic assumption of that what the particular is in itself. Yeah, so that is what I call a counter right. So it's a right that can only be articulated against by making your point, yeah, in that negotiation with the universal. Yeah, you cannot just retreat from the claim of the universal by saying, I have a right to that and that because it makes up my nature. Yeah, that is not a possible move, but I can only say I can only make that claim in a negotiation with the universal by implicitly saying, or by implying, by claiming that our form of living together is only a good one if it makes this kind of exceptions to the togetherness of our life. Yeah? So a privacy, an idiocy, a particularism, a non-participatory moment, and so on. Yeah. So, but this is not because that is my nature, but because it's good for our common way of life to make that kind of give room, in a certain sense, to those non-participatory moments. Yeah. I mean, a different understanding, if you want to, but I know that this slippery slope, a right to privacy. Yeah. Which is a very dubious right, I think. But I mean, so a different understanding of that. That would be, so I don't know who asked the question. I don't know where to look at. So that would be the idea of a counter right. Yeah. So it's a right because it's about the particular over against the universal. It's a counter right because it's not pre-given, not grounded in something which is pre-given, but it's an effect of that negotiation with the other side, and therefore changeable. Yeah.
We have a question from Daniel Quiroga Villamarin. Daniel?
Wonderful. No, thank you very much, Alexis and Professor Menke. It's good to see all of you again, even if virtually, sadly. I will take you back a little bit to the conversation with Alexis on non-human rights, because the exchange made me think that one of the things that I always return in Marx's the Jewish question is this idea translated in English as of the species being. I won't make the embarrassment of saying it in German myself, but it's always something that I found promising in the way of maybe thinking about rights that are distinctive to us as humans, or let's say a political community that is composed as humans as such, as a species, and not necessarily as a collection of atomized individuals. So maybe I'm just not familiar if you have engaged this already in your work, but seeing we have the opportunity to ask you, I was just thinking, what do you make of that idea of the species being in Marx? And does that hold any sort of political promise to rethink polities and rethink political projects, especially because it seems to me that it can at least in different ways respond to that question of representation that you were posing. But thanks again, and it's been a wonderful conversation.
No, thank you. Thank you for your question or your hint. First of all, I have to admit I didn't really think about that term. Yeah, I think also you're right. It's promising maybe in two ways, or it would be promising to think about it more in detail in two perspectives. So the first is the following. I mean, I think there's a certain ambiguity in the early Marx. I mean, that is trivial, yeah, but it's a specific ambiguity you have in mind, yeah, because on the one hand, he is in many contexts, especially in his engagement with Hegel's distinction between bourgeois society and the state, he's very much relying on, let's say, the Rousseauian opposition between the individual and the part, yeah, the partie, Rousseau says. So, I mean, this is this famous formulation Rousseau is using. So what does it mean to constitute a political unity? What does it mean to institute a people, he says? It needs an ontological transformation of the self-understanding of us as individuals or atoms, yeah, and the self-understanding of us as being parts of a community, right? And that is the transformation, the revolutionary transformation, right, that Rousseau has in mind, to transform our being from being individuals, so self-preserving biological entities, to being social beings, that means parts of a community. And as I tried to say at the beginning of my talk, why I think what the motive here is, the motivation here is, but I think that this distinction is too simple. Yeah, basically the whole paper is about saying that is a too simple distinction, right? Because we will forever be both. Yeah, so it does not make sense to say we make the step from one to the other. Or if we make the step from one to the other, we have to make the step in such a way that remember what we've been before and inscribe, in a certain sense, that memory of that other side, yeah, of this pre-social side into the social form. Yeah. So that is what not really making the step by forgetting the beginning, but making the step in remembrance of the beginning. This is what one could call self-reflection here. Yeah. So this is what I meant. And maybe what Marx's term Gattungswesen, species being, is meant to refer to this split, in a certain sense, to that tension, right? To that cannot be overcome, right? Because the Gattungswesen is social and natural in a certain sense at the same time, and is about that relation between the social and the natural, which in Rousseau's, in a sense, that teleological account is a replacement act. Yeah, and I think Marx did not think of it as such a kind of replacement. Maybe this is a certain kind of Schellingian element in him, so where the relation between spirit and nature, freedom and nature, is also thought as being a relation of negotiation of that distinction rather than of overcoming the one into the other. I don't know. Yeah, so maybe that would be a fruitful way. So one could read Marx in that perspective, right? And the other advantage, but I don't want to talk too long, I mean, of the term species being and Gattungswesen is, and that comes back to the point by Alexis, that means that Marx in his early approach is from the beginning thinking the human being as a natural being, yeah, as part of nature. Yeah. And then, I mean, from there, I mean, this is done a lot now in the contemporary discussion. So maybe we could read Marx as offering us another account of what it means to see yourself as a natural being in what he called Stoffwechsel. So I don't know what, I mean, in a circular process integrated in natural processes. Yeah. So that could also be a promising way, I mean, something promising in that idea, right? I mean, to find, I think, a very sophisticated, very interesting way of accounting for our naturalness, yeah, of the way in which we are natural beings, yeah, because Marx, of course, thinks we are this different from a plant and an animal, but we are this by nature, different from that. Sorry, that is just very brief, but I think it's a huge question you're opening up.
So our time is almost up. So if we don't have any other question, we can maybe wrap up here. So thank you so much, Professor Menke, for joining us. It was great to listen to you. It was great to know about your work, your critique of rights, which is, I think, highly relevant for the reasons that we have been discussing so far, especially now that we are thinking about extending rights to other than human beings. So thank you so much for that. I would like also to thank Gulsh. I don't know if you are there, Gulsh from the Queen Mary events team, for all her support with this talk, but also last week with the previous talk. Thank you so much, Gulsh, for your support. And I will also thank you, all of you, for joining us today. Thank you to Marcelo and to the rest of the members of the group of critical studies. Please join us again next year. We are going to continue with the Critical Legal Talk series, probably from February onwards. We are going to distribute the list of speakers in the next few months, probably. So please join us again next year to continue with these discussions. So see you then. Thank you so much again. And,
yeah, thank you for having me. It was a pleasure. So thank you so much. I enjoyed it a lot.
Thank you, Professor
so much,
Menke.
Professor.
Thank you very much.
See you all.
Bye-bye.
Thank you so much. Bye-bye.
Bye.